right, so my name is John Choi. I am a fellow at NYU Law School, and today I'm going to be talking about statutory interpretation. The big question over the past 30 years in statutory interpretation has been, should courts be textualist or purposivist? Textualists are those who focused on the text of statutes and tend to emphasize the plain meaning of the words therein. They use dictionaries and other tools like that to find the meaning of the words. On the other hand, we have purposivists who tend to look to legislative history and take a broader view of statutory meaning. So although that debate has been raging for a long time and has quieted down a bit in recent years, increasingly scholars are looking to statutory interpretation not by courts, but by agencies. So agencies have been hypothesized to be more purposivist than courts, perhaps because they have a lot of experts who can read legislative history better than courts, perhaps because of their particular legislative mandates. There's also been a suggestion that agencies may not be engaging in interpretation at all when they make rules. It may be that agencies have a range of acceptable interpretations, and between this range, they pick the best policy on normative grounds, rather than seeking the best interpretation as a court might do. But these are theoretical suggestions, and there's been very little empirical work so far comparing the practices of agencies and of courts. So what I do is I take an attack on this question from an empirical perspective using the IRS and the tax court. These are both very large organizations, so the IRS is one of the biggest federal agencies, so we have a large body of documentation to analyze, and they've been operating for a long time because the tax code has been running since the start of the Republic, and the modern IRS has been running since 1919 with the start of the income tax. So what I do is I look at two main data sources. First, there's the Internal Revenue Bulletin, which the IRS has published on a weekly basis for the past 100 years. And that I did manually. I downloaded it and then conducted OCR myself, did spell checking. It took a long time. So thank you to the Case Law Access Project for providing the court data, which took maybe 30 minutes to code up. The methods that I use are natural language processing and machine learning. I'll talk about the machine learning a little bit, but the main method that I use is to look at the term frequency of certain terms that are correlated that can be used as proxies for particular ideologies. So as I mentioned, textualist judges and textualist agencies will tend to cite dictionaries to get at statutes' plain meaning. They also use certain language canons. On the flip side, purposivists tend to cite legislative history to try and figure out what a statute means. And these are proxies that have been widely used in the past in the literature. Okay, so what are the results? First, on the question of normativity versus interpretive approaches to statutory interpretation, the IRS, as one might expect, has become much less interpretive over time and much more normative over time. And you can see there's a big inflection point around 1984, which is when Chevron comes out. Chevron, of course, provides a Chevron space that provides deference to agencies that select the best policy. So as one might expect, after that point, the IRS becomes much more normative. In contrast, and by the way, this is term frequency on the left-hand side, so it's the number of times you cite terms associated with one of these. So for normative decision-making, it would be terms like efficient tax administration or fairness. And for interpretive decision-making, it'd be talking about interpreting the code or construing sections of the code. With the IRS, and this is indexed, we can see that they move relatively in tandem. So there hasn't been much of a change in the relative mix between these two over time. The second question is textualism versus purposivism. So what we've seen at the Supreme Court, for example, the paradigmatic path that courts take in their interpretive methodology is that at the beginning of the 20th century, they're pretty textualist. This is the old textualism. Then FDR arrives. He appoints a bunch of liberal justices. Hart and Sachs come out with legal process purposivism. And during the 30s and 40s, the court becomes much more purposivist. It peaks in the 1970s. Then in the 80s, Scalia is appointed. He brings the new textualism. Purposivism goes way down. Textualism goes way up. That's what we would expect to see at a court. What do we see at the IRS? We see no new textualism. The IRS has, if anything, become more purposivist over time. And although there's a bit of a decline in purposivism too, recall that all forms of interpretation slightly declined since the 80s at the IRS. So in the relative mix, it's still become, if anything, more purposivist. So it's not like a court in that respect. But the IRS is much like the Supreme Court and most other generalist courts. It peaks and then declines in purposivism, and it becomes much more textualist leading up to the present day, although this happens at a lag, so about 10 years after the Supreme Court. As again one might expect, because the Supreme Court was an innovator in this respect. So now is the part where I use machine learning to get a little bit more granular. Those were basic trends, but we can use machine learning and supervised learning to ask, can methodology predict certain outcomes? For example, case outcomes, whether the taxpayer wins or the IRS wins, or political party. So do Democratic appointees try cases differently than Republican appointees? The answer to those questions is no. There was very little predictive power when I tried to run these, and that's the Matthews correlation coefficient. It's an instantiation of the Pearson correlation coefficient, and so values about 0.1 or less, very little predictive power. In contrast, in trying to distinguish between courts based on methodology, the results are pretty good. Oh, and sorry, even though party doesn't predict methodology, what does predict methodology is the year of appointment. So some of the most textualist judges are Obama appointees, which is the opposite of what you'd expect, because normally textualists are conservative. But what really happens is that after the year 2000 or so, notably after a lot of these appointees will have gone to law school and been taught about things like textualism, we see a dramatic uptick in the amount of textualism in their opinions. And they're relatively, within judge, they're relatively methodologically consistent over time. So in contrast, what methodology does predict is the court that actually wrote the decision. So I look at tax courts versus generalist district courts, and I also look at the tax court versus the Court of Federal Claims. And by using these, and by looking at the weights assigned to each term when I run it through the predictive program, you can see which terms are most tax court-like and which terms are most district court-like. And from these, I produce these word clouds. So the green terms are the tax court terms, the red terms are the district court terms, and the size of the term is the strength of the association. So I separate these into legislative history, textualism, and substantive canons. In legislative history, it's basically what you would expect. The tax court tends to rely on the Joint Committee on Taxation, that's the Joint Committee, the CBO, and it tends to reference conference reports, which are the last reports in tax legislation. In the substantive canons, these are deference doctrines: Skidmore deference, Chevron deference, Auer deference, which is the same as Seminole Rock, which is, again, what you would expect because tax law is very agency intensive because the IRS is so heavily involved. And the textualist canons, I didn't have any priors on these, but I suppose it makes sense ex post because in pari materia says you should read different sections of the code in tandem when they deal with the same subject matter. It's a kind of full acts concept that's quite common in tax law. Notably, when we look at the word clouds for the Court of Federal Claims, there are some differences, like increased reliance on the absurdity canon and less Chevron deference at the tax court, but there are some commonalities. So the legislative history is about the same, and there's the same reliance in pari materia. And so even though all of these courts have followed the general trend, when they became textualist over time as part of the new textualism, the way in which they do so differs between these different authorities. So that's it. Thank you.